joining this this joint webinar between Moore-Kingston Smith and Hudson McKenzie on making sense of Brexit implications for international employment scenarios. My name is Richard Cummings. I'm a strategic HR partner for Moore-Kingston Smith HR Consultancy, and I'm joined today by Rahul Batra, managing partner of Hudson McKenzie, together with his colleague, Solicitor Vaida Lukaite, and Moore-Kingston Smith's Director of Global Mobility, Steve Asher. In a moment, we'll hear from Rahul, who'll give us an overview of Hudson McKenzie, and then Vaida will be updating us on the immigration changes, followed by Steve, who'll be giving us an overview regarding social security changes. Both Vaida and Steve will share some case studies to help us visualise how these changes may work. We're scheduled to finish at 11 o'clock. Please feel free to ask questions in the Q&A function, but not the chat function, and we'll have some time at the end to try and answer these questions. This webinar is being recorded and we'll distribute the slides afterwards. I have to give the usual disclaimer. If you're watching the recording in the future, some items may have been updated. This is the usual. Your vote may not count, but you may still be charged. We're due to kick off in a minute, but just before we do, I'll just have a couple of slides and then I'll pass over to Rahul. Okay, so UK citizens and their families. So by the 31st, most people should know this by now, by the 31st of December 2020, anybody living in the UK for more than 5 years, they can apply for permanent residency and then British citizenship. If you've got less than 5 years by the 31st of December, then you can wait for 5 years and then you can apply for your settled status, and family members are the same as it states there on the slide. Okay, so this applies to EEA citizens and their family members who entered the UK by 30th June 2021 if there is a deal, and if there's no deal, it is by the 31st December. Whether there's a deal or not, who knows, but we'll wait and see. Okay, I'm going to pass over to Rahul, who gives an overview of Hudson McKenzie. Thanks very much.
Thank you, Richard. I'm Rahul Batra. I'm the managing partner at Hudson McKenzie. Today we'll be covering the immigration changes which have been announced recently. And as most of you would know, these are sweeping changes which changes the entire dynamics of how the Tier 2 route works. There are specific things to take note of, like resident labour market test and the restricted cause, which my colleague Vaida will be covering in the slides later on. But if you have any questions later, we are there to help. We'll have a 15-minute Q&A at the end of the slides. So feel free to ask us any questions at the end. So over to you, Vaida. And
thank you very much, Rahul, and good morning, everyone. I'm very, very pleased to be here with you this morning, and let's dive in right into the immigration changes. Visitors will be permitted to study on visit visas for up to 6 months, but it will not include recreational courses, which last less than 30 days. Students also who wish to come and study short-term English course, the course must be between 6 to 11 months. If we could have a next slide, thank you. English language level will only need to be met once. Malta has been added to the list of majority English-speaking countries. Also, applicants will be able to use UK A-levels or a degree from an island, from Irish universities, basically, to meet English language requirements. Regarding maintenance, electronic bank statements will be accepted, and applicants will be able to rely on a wider range of accounts. Skilled worker route will replace our existing Tier 2 general. Skilled worker route will open at 9 AM on 1st of December. UK companies must hold a sponsor license in order to sponsor overseas workers, which will include EU nationals from the 1st of January. Minimum skills threshold has been dropped to level 3, which is equivalent to A-levels, and the salary threshold has been dropped from 30,000 to 25,600 per year, which can be even further lowered by using tradable points. However, applicants will need to score 70 points in total, of which 50 points are mandatory. Restricted quota has been removed, along with a resident labour market test, and the salary for ILR has been dropped to 25,600 or a going rate per skilled occupation code. Applicants in shortage occupation or those in healthcare occupation can be paid 20,480 if the salary is the same or exceeds going rate for occupation. If we could have the next slide. Thank you. Just to understand tradable and non-tradable points better, we gave you this points breakdown. So the mandatory 50 points
Okay, we seem to be having a few internet problems with Vaida there at the moment. So if you just give her a second.
Back yet?
Okay, you're back. You're back.
Yeah?
Yeah.
Okay, perfect. Great. Probably I've left at the skill level. So skill level at the minimum of RQF 3, which will score further 20 points, and an English language which will score 10 points. So that combined makes 50 mandatory points. Tradable points can be scored for salary, which would reduce the salary that must be paid to the migrant worker. However, it cannot be lower than 20,480. Also, for having PhD or PhD in the field of science, technology, electronics and mathematics, or having a job offer in shortage occupation. Okay. Here I am going to share a short case study with you, which will just present how tradable points will work in practice. So Rob has been offered a job as a veterinarian with a salary of 26,750. He meets all requirements under the new points-based system, scoring mandatory 50 points. His salary is higher than the minimum threshold of 25,600, but the going rate for veterinarian under the Skilled Occupation Code is 32,500. Therefore, he does not score 20 points for salary. His salary is 80% of going rate for his occupation. He can score the remaining 20 tradable points elsewhere. As his job offer is in shortage occupation, he scores the remaining 20 points, which in total scores the required 70 points. Okay. Now, in relation to ICT, Intra-Company Transfer, the cooling off period completely has been removed for intra-company ICT visa holders. Now they will be permitted to hold an ICT leave for up to 5 years in any 6-year consecutive period, or up to 9 years in a 10-year consecutive period if they are high earners. The new single high earners threshold is set at 73,900, and the previous second threshold of 120,000 has been completely removed. The minimum threshold remains at 41,500, but this is based on 48-hour working week, and the going rate for the Skills Occupation Code is based on 39 working hour week. Applicants also will be permitted to switch to an ICT route from within the UK, but this route will not lead to settlement. However, I think this is a very important point to note, because a lot of people have been asking. Migrants will be permitted to switch from ICT to skilled worker route. The only thing is that the time spent on ICT will not count towards ILR, therefore the clock will start again. Okay. Frontier workers. So frontier workers are the EU, EEA and Swiss nationals who are employed or self-employed in the UK, but they live elsewhere. These workers will be eligible to apply for Frontier Worker Permit, which will be launched on 10th of December this year. And these permits will be issued at no cost. Frontier workers can continue entering the UK with their EU ID or passports, but the permit will be required to enter the UK from the 1st of July. If we could have another slide, thank you. Frontier worker scheme applies to those whose contract started before the 31st of December this year. However, should their employment start in the UK from 1st of January, they would need to apply for a visa under the new points-based system. Okay, and these are the major points that we wanted to highlight in relation to the new points-based system. And now I will hand over to Steve.
Thank you, Vaida. So I'm going to very briefly look at the Social Security position. Just as frustratingly as everybody else, we don't have any finished answers at the moment because we don't have a final agreement. We're still in that halfway stage of will things change, won't they change? So in terms of planning, we have to think about what could we be getting ourselves ready for. So if we go back to basics, the idea of the existing rules are that you only pay Social Security in one member state, and that state is normally the country in which you're working, unless you're on a short-term assignment that's defined as less than 2 years, or you're working in more than one member state at the same time, which has got a quaint title of a multi-state worker, or in very limited circumstances, which are, if somebody has particularly difficult personal circumstances, such as claiming different benefits. In those situations, you're able to continue to pay into your home Social Security system, and normally this involves obtaining what's called a certificate A1. Next slide, please. So the people it's affecting, in terms from a Social Security point of view, will be those who are being sent to work in the EU from the 1st of January 2021, but not for the Irish position. So if you've got Irish nationals or UK nationals working between the two countries, those moves will be covered by a separate excuse me, reciprocal agreement, and therefore it's less of a concern when you're working with those moves. Next slide, please. So the situation, however, if we don't reach an agreement, becomes slightly more complicated. You'll have two different groups of individuals you'll need to think about. Those who have effectively an A1 in place, so long as there isn't an interruption of any description, and what they mean by an interruption is they continue to work without interruption, but not defined. So your guess can sometimes be better than mine as to what that means, but I would imagine the COVID situation, should it continue, might mean that there's an interruption, and whether that will mean the A1 then doesn't continue to apply, we're not sure. So when you're looking at your staff with A1s, you'll need to think about what might be happening to their arrangements in the next few months. The situation for individuals who are not covered by the A1, which is likely to be those who are moving after the 31st of December, will depend on whether or not an agreement's been reached. So what could happen? We could be looking at some sort of agreement that replicates existing rules, in which case, apart from maybe some admin changes, things will be easy to understand. We might have a situation where the government negotiates a separate agreement with the EU, which will broadly have similar treatment, but there might be some nuances that we will have to pay close attention to. So watch this space. But the doomsday scenario, I guess, from a social security point of view, is that there is no agreement reached between us and the EU for social security purposes. And then you could be facing the nightmarish scenario of paying social security both in the home country and the host country without any set off or any credit for that. So overnight, if you like, potentially doubling, if not more, the social security costs for the employer and the employee. Next slide, please. So things to look at in terms of where could the risks lie. This is what we'll be trying to highlight for you in our published publications over the next few weeks and months. Is if you're looking at workers who start before the 1st of January, those with existing A1s effectively, then it's going to be, if there's any interruptions to their arrangements, potentially loss of coverage. So they might fail to continue to meet the requirements, and they may suddenly be exposed to any new arrangements, including that potential for double charges if that's the scenario we're faced with. For those who are applying for an A1 after the 1st of January, again, you've got a whole new set of application procedures. They may or may not be familiar to us. I would imagine there'll be a whole set of processes we'll need to learn, new forms we'll need to become familiar with. So there may be an admin challenge there for a number of employers. The other thing you need to think about in terms of the doomsday scenario is, in addition to the potential double contribution charges, there may also then be a loss of healthcare and benefit coverage. If we weren't able to continue with our EHICS, the card we can carry around that enables us to be able to access medical treatment, if that goes, then we would need to be advising employers to look at their existing health insurance and similar things. Next slide, please. So what can you do given this unhelpful scenario where we really don't know the answers, but we can try to anticipate some potential downsides? Well, to state the obvious, I guess, review your current and planned arrangements. Who are you thinking of sending anywhere? And try to think about what could be happening there. Check the expiry dates of your existing A1 certificates to ensure that they cover the full period you want them to. And if they're not going to, then by all means talk to us. If not, talk to us. Consider how you're going to deal with any shortfall. Consider whether or not you can bring forward the start of any transfers to the EU. I know in the current world that might sound unrealistic, but it's something to think about in terms of the application process for the A1 certificates. Equally, you might want to, if you haven't already done so, to review your health and travel insurance policies to make sure what they will and won't cover, and whether you need to consider discussing with your insurance brokers, extending what coverage you can offer your transferees, and be prepared to learn new things. On top of everything else, I know the HR specialist has to deal with it at the moment. I'm going to suggest you're going to have a whole load of new stuff to learn. We, again, in our publications, will try and explain what these might be. But I guess the challenge for you is to decide what they are and how you're going to cope with the extra burdens. So I guess in summary, from a social security point of view, watch this space, but watch this space daily. It's not one of those things that is on the breakfast news in the morning about how the EU social security regulations are going. There are, behind the scenes, a number of agreements drafted that would effectively mean that we can carry on as we are in effect. And that certainly was the anticipation of the original withdrawal agreement. But as we get closer to the deadlines without any clarity, I think it's important that you do start to consider the scenarios of no agreement being reached and what you would do. Next slide, please. So we're now going to look at a couple of case studies. I'm going to try and only focus on the social security aspects, and then Vaida's going to deal with the hard stuff on the immigration. Next slide. So the first case study is for Francoise. She's a French national, lives with her family near Paris. She's been employed by a French business for 20 years, and then she's luckily assigned to the UK for 2 years. She's due to arrive in October next year. A sister company holds the sponsor license. So what's her position? Well, you've got to look at if things continue as they are, because she's being assigned to the UK for no more than 24 months, she can remain in the French social security system under the existing social security regulations. You would then make sure that she got a certificate A1 from her French employer, and that would mean from a UK perspective, there'll be no NICs payable by the UK company or Francois. However, if there's no agreement at all, and there's no reciprocal arrangements put in place, then she would remain liable to both French contributions and would also then become liable to UK contributions, meaning we have a potential double additional charge. And also, if there's no agreement in place, she wouldn't be necessarily able to obtain medical treatment in the UK without some form of insurance to help cover it, and therefore increasing the costs to the company. And if the company cannot or choose not to cover that, then clearly that's a major inconvenience. And perhaps when Francois is deciding whether or not to accept a UK assignment, that will be a key consideration that she takes into account. So moving on now for Vaida to give her views on what the immigration perspective might be.
Thank you very much, Steve. So as Francois is coming to the UK after the 1st of January, Francois will need to enter the UK under the new points-based system route. It's good news that the company in the UK already hold a sponsor license, therefore they can sponsor Francois. We would recommend to apply for an ICT, as this seems to be a short-term assignment, up to 2 years or so. And given that she's been employed by the French company for over 12 months, and provided that her salary is above the 41,500 per year, she's basically fine. She would qualify for a Tier 2 ICT. Her salary can be paid by her employer either in France or the UK throughout the period of assignment. And also she is completely fine to bring her family. Her partner can even work in the UK. The only other probably thing to note is that this visa would not lead to an ILR. However, under the new rules coming into effect, should anything change for Francois and the business decides that it's good for her to stay in the UK, she would be eligible to switch from Tier 2 ICT to skilled worker route. Okay, and back to you, Steve.
Thanks, Vaida. So the next case study, let's look at this for Mohammed. Mohammed's a British engineer employed by the UK company. It's assigned to work in the Netherlands for an initial 12-month period that will start in April 2021. So again, I'm not going to cover the rest of the case study and then look at the tax, because the tax situation for the moment will remain pretty much the same. I'm just going to focus on, as we did with Francois, what would be the potential social security position. So again, if things stay the same as they are in effect, even if the administration changes slightly, Mohammed will be able to stay in the UK social security system and not pay any contributions in the Netherlands. Netherlands, if we have retained the EHICS or anything similar to that, be able to obtain medical treatment, etc. And that would all be familiar to everybody, and so plans could continue pretty much uninterrupted. Again, for Mohammed, it's similar to Francois. he still could potentially be facing contribution liabilities in both the UK and the Netherlands. And as the current social security systems work, there wouldn't be any equivalent to double tax relief. You would have, therefore, a real genuine double charge and extra costs to bear. And again, similar to Francois, if no agreement's reached, obtaining medical treatment might become a problem. And if no alternative arrangements are put in place, he would then need to look to his employer for some other form of private insurance arrangements to enable him to access medical treatment should he need it whilst he's in the Netherlands, or in traveling around anywhere else within the EU whilst he's there. That's again the type of scenario we're looking at. In both the cases of Francois and Mohammed, the thing to also look out for is some companies will have what's called a tax equalization policy, which in simple terms tries to say that people will not, on assignment, will not pay any more tax than they would pay if they'd stayed at home. So any extra tax they might have to pay because of working on assignment is met by the employer. Most of these policies do not extend that to Social Security because it's not been an issue in that regard for people moving within the EU. So if you do have an equalisation policy in place, it would be important to review whether or not it does extend to things like a double Social Security charge. And if it doesn't, you will need to consider whether you want it to be amended in some way to accommodate that. Clearly, it would carry a cost for the employer. That can become complex if you're not familiar with that type of arrangement. But definitely, it's one of those things that you should not assume will cover you in these sort of situations. And you will need to review your policy carefully. Vaida, over to you for the difficult stuff, please.
Thank you very much. So from 1st of January 2021, UK nationals will be treated as non-EU nationals. In order to benefit for a fast track immigration application program, the sister sponsoring entity can become recognized with the Dutch immigration authorities. Once the company is registered, the entity will be able to benefit from expedited processing times and less supporting documents for any ICT applications going forward. In terms of Mohammed's application process, the work and residence authorization would need to be filed first prior to his arrival. On arrival, he doesn't need like an entry stamp or any entry visa to enter Netherlands. But once in Netherlands, Mohammed would be required to attend immigration office, and then once that's done, then the final step is to register with the town hall and obtain social fiscal number, which is like national insurance. Also, a little disclaimer, obviously negotiations are still ongoing, and if it's all highly dependent on the agreement between the UK and the EU as well. Okay, and thank you, and I'll hand you over to Richard.
Okay, that's great. Thank you very much. There's, okay, that was incredibly interesting. We've got a few questions in the chat, or in the Q&A rather. So this is quite a good one. So we're an event company that uses lots of freelance contractors. Much of our work is across the EU, and it covers requirements we need to put in place. And we send our employees and contractors to Europe to deliver on an event. They can sometimes be on site for a few days, up to a couple of months. Is there anything specific visa-wise that we need to do?
I guess it depends. Potentially, this is where the frontier worker visa would apply if their contract is already in place. So if they, for example, they are residents in the UK and they get sent, as an example, to Spain for a week, 2 weeks, or even a month or couple of months, and then comes back and then goes back to Spain, they could potentially apply for the frontier worker visa. If they, trying to think what else could here apply.
Well, it's such a short amount of time that this isn't going to affect social security payments or anything like that, because I assume just because they're going to be in the EU for 2 weeks or 2 months or something.
The thing is, if they are going there for work, they do need to have a work permit. Otherwise, if it's only like attending meetings, they could probably get away with a business visit, which means they don't really need anything at all.
And how long is the business visit visa?
You can actually go to Schengen area post Brexit up to 90 days and stay there within 180-day period.
Right. Okay. Fine. Okay. Great. Okay. So we've got another question. The rate information form. Where does that come from, or where is the going rate information obtained from?
Okay, so we do, this is something what the Home Office publishes. So we do the going rate, i.e. the skills codes, etc. This is something what Home Office provides. So we have the amendments already that were provided to the Parliament. So we do have the list of skilled occupation codes, which consists of salaries, like a minimum salary for this specific code that needs to be paid, including the ICT work.
So we've just had the event company again. So the employees are going to be paid from the UK. I assume, does that make any difference?
No. Again, it sounds like potentially the frontier worker could apply for them, but obviously we would need to look into this in more detail.
Okay.
And I think I'd like to add here, if we also need to find out which countries these people are going to, because every country will have some sort of different requirement. So perhaps after the webinar, if you could send us the list of countries where these people are going to, we could come back to you with what the requirements potentially could be, and then advise accordingly.
Okay. Thanks very much. Okay, so we've got another one here. So are the UK social security authorities currently still issuing multi-state A1 statements based on EU regulations?
Yes, they are. Basically because they have to, because the current regs are in place until something else comes along. However, my understanding is that they're looking at these more closely, but they are still being issued, and they can apply for an end date after the 31st of December. And that goes back to the point we made earlier in the presentation, that so long as the A1's issued before the 31st of December, for work that goes for a continuous period afterwards, then you're okay. The issue might be if there is a reason why the work wasn't continuous. And as I said to you, unfortunately, there's yet to be a clear guidance on what's meant by an interruption and what's meant by continuous employment. But assuming that it's common sense is applied, the multi-state worker A1s would still be relevant up until something else replaces the legislation.
Okay, great, thank you. There's okay, so here you go, got another one. So can a UK company sponsor a third-party contractor who is performing engineering work in the UK under a skilled worker category?
I presume the question is whether the company who's sponsoring the migrant worker would be able basically to lease that worker to someone else. Looking at the amendments, it seems that they don't really like that type of scenarios, and it basically states if you are sponsoring migrant workers, they need to be your migrant workers, i.e. either your employees or your sister company's employees.
Okay, thanks very much. Okay, and then is there anything we need to consider for high earners, so people in that 160,000 a year category?
Not really. This kind of remains the same. So if your salary is above the 159,600, you're free to travel. to the UK. I mean, there's no resident labour market test regardless. Again, there is no restricted causes, so there's no quotas regardless. So pretty much same rules would apply, but obviously because your salary threshold is way higher, you can, you basically have a green light.
Okay, great. So we've got a follow-up one with regards to the A1 statements. So regarding A1 statements issued after the 31st December, could the local authorities of the other country or countries dispute if the A1 is valid after this date?
Yes, they could always dispute whether an A1 is valid. They're not automatic. There are requirements that have to be met for the A1 to be issued. And one of the things we're finding in practice is that some countries are examining A1 applications very closely because of the ongoing discussions, and in some cases are questioning whether they will issue them when they do go beyond the 31st December. But technically, if the EU regulations remain in place, there isn't going to be a valid reason to invalidate the A1 or dispute the A1 other than to say, why would they allow it if it's for a period where we don't know what will and won't be viable. But I think in practice, other than people being awkward, if I can put it that way, the A1 would still be relevant.
Okay, great. Okay, we've got a couple of questions about posted workers. So for posted worker notifications, a posted work permit for UK nationals is not required at the moment in the Netherlands. After January 2021, a work permit will be required. Could you please inform us which permit procedure is then required? Frontier worker permit is not applicable in this situation.
So I presume they already are posted workers. So this still remains, i.e. the cross-border agreement still remains. So if this is what they currently already hold, you can continue using this option, if that was the question, if I understood that correctly.
Yes,
Sorry.
that's what it sounds like. Okay.
Yeah.
Okay, thank you. Okay, so okay, we are a small software company and don't need staff to physically be in the UK, so have staff in Portugal and Finland. We've previously tried to navigate the A1 and had Finnish-based staff as UK employees, but it was amazing how both UK and Finn tax authorities don't really know how to handle the situation. Is there a better route than subcontracting? With ironclad IP assignments, so based in EU, working for UK micro SMEs.
Is the question, what's the alternative to subcontractors in order to obtain A1 certificates?
Yeah, I think so. I guess people aren't physically in the UK, are they? So if they're not physically in the UK, but they're working from another country, does that have an implication here with the A1? Yeah,
it does have an implication, because clearly the A1 assumes that person moves from country A to country B and wants to stay in the social security system of country A and not pay into country B. If you're actually sort of living or working in country C, then it makes it slightly more complicated for the authorities to make sense of. And as you say, they don't know how to handle the situation often, because the current realities of how people are working weren't anticipated when the rules and the guidelines were put together. Is there a better route to subcontractors based in the EU working for that sort of business? Well, the only other routes you could be looking at would be, rather than subcontracting, making the subcontractors employees, but clearly that involves a whole host of other commercial considerations, which you know, in the same way as people would say the tax tail shouldn't wag the commercial dog, maybe it's the same for Social Security. But yeah, I think it's a more complicated question and therefore an answer than I could possibly cover in this sort of situation. But there may be ways, if you reviewed why you're having people who've subcontracting in the first place and what the options are, there may be ways to make the Social Security application easier.
Okay, great. Thanks very much. Okay, can we apply for skilled worker category for those employees completing 5 years in the UK on Tier 2 ICT? We will not be looked at a company allowing settlement route. What is the percentage of skilled workers to Tier 2 ICT should one maintain as a company?
I see. So I believe the question is whether someone's completing 5 years already.
Yeah, that's right, on the
Yeah,
ICT.
Yeah. Oh, sorry, was it an ICT? I think
Yeah, it's an
general.
ICT. Yeah, ICT.
Yeah, that is fine. If it's an ICT holder, they can switch to a skilled worker route, and then obviously stay in the UK on a skilled worker route for the next 5 years. If they are their salaries are below the 159,600. If they don't want to settle, that's fine. 5 years later, they would still need to then leave the UK.
Okay, perfect. Thanks very much. Okay, can we hire a D visa ECAA business category candidate?
D visa, sorry?
D visa. Yeah, can we hire a D visa? This must mean more to you than me.
I am not quite sure what that means. Sorry.
Okay, if we could just ask that, that person to
yeah,
repost
if you
the question
could
a bit more specifically.
Yeah.
Okay, thanks. And okay, some advice for HR. What should HR people be doing?
HR people, I guess for them it's more likely to pay attention about right to work checks, etc. This is probably what they would be looking at. Also, how can they recognize like EU workers who's potentially been in the UK prior the 31st of December or who arrived after the 1st of January. So probably these are the main points that they would need to look at, because obviously if the EU nationals been here already, they probably either have pre-settled status or settled status, or they are eligible to apply up until the 30th of June next year. However, if it's someone newly arriving, they would need to be sponsored. So probably HR would need to sort of ask that type of question. When did they arrive, for example? In terms of right to work checks, again, at the moment, the current guidance is that you don't really need to do anything with EU nationals apart from get a copy of their ID or passport, and that completes the right to work check. However, we have a feeling that the new guidance probably will be released post 1st of July, which will give a little bit more detail how to treat EU nationals after that date, where the pre-settled status applications will end.
Okay, great. Thanks very much. In terms of English language tests, how are the English language tests going to be administered? Do we know that?
How will they be administered? So at the moment, we still have the list of approved UK Home Office approved language sort of skills providers, right? Who's basically carrying those tests, and that remains in place. So you either need to take the test through one of the approved bodies, or you have a UK degree, Irish degree, or you are coming from one of the countries which are majority English-speaking countries.
Okay, great, thanks. And Steve, the social security, so paying social security in 2 countries, that's something that must happen now all over the world, right?
Outside of the EU, it can happen. It's not an unfamiliar conundrum, if you like, outside of the EU. For this, clearly, we're concentrating on people becoming comfortable with EU transfers and not having that problem. But clearly, when you're looking at international social security, you've got countries in the world with which the UK has agreements, those with which we have no agreements, as well as the EU social security regulations. So if you look at the countries where we have social security agreements, for example, the US, there's a similar sort of treatment to the EU regs that says you're effectively subject to certain conditions being met, etc. You'll only pay in one system, not both. But if we're looking at those countries where we don't have any agreement in place, and there are still surprisingly quite a number of those, then yes, Richard, you're entirely right. You do then have the potential problem that you might be liable to, for at least a period of your assignment, to Social Security in both.
Okay, perfect. Thanks very much. Okay, do we need to form a right to work check on an ICT or skilled worker?
Regardless, whoever you employ as an employer, you have to run the right to work check. It can be even a British national. Regardless, you do have to run the right to work check. So obviously an ICT holder or a skilled worker visa holder, you would need to see their passport and a copy of their visa.
Okay, great. Thanks very much. Okay, so we've got a very specific one here. So will an English language test taken in 2015 from Trinity College still hold good for applying for a skilled worker category now?
Usually they are valid only for 2 years. So we would need to look at that specific test. There is a likelihood that it has expired, but as I said, we would need to look at the actual test.
Okay, perfect. Okay, and we've got one about pension contributions. How will pension contributions be handled in the EU? Employees that will move or have moved from EU to UK?
Well, that's going to depend on whether or not there's an agreement. Under the current, what they call coordination rules, if you pay contributions to the country that you're working in, rather than the country you're going to be going back to and living in, the coordination rules allow those contributions to still continue for pensions purposes in the home country effectively. And that's the glory of the current EU regulations, that you can be paying contributions into a host country system, but nonetheless the coordination rules allow those contributions to count for pensions purposes. So if you look at it from a UK perspective, you have to make contributions into the system for a particular number of years. That will include, where it's necessary, those contributions you've made into an EU scheme. If we fast forward, if we're in a situation where there is no agreement, and we're in what I refer to earlier as a potential doomsday scenario, then question mark whether or not that coordination agreement will be replicated. If it's not replicated at all, then we do run the risk of potentially making contributions into a host country scheme that aren't then counted towards the UK scheme. I would hope common sense prevails, and that isn't what materializes, but that's the risk that's being run whilst we're in this what one might call a transition period. I prefer to call it the silly period.
Okay, great. Thanks very much. Okay, we've got one to everybody here. So is the panel surprised that with less than 6 weeks to go, there is little visibility on employment laws?
Definitely. There's a lot of ambiguity in terms of, let's say, right to work checks for EU nationals. Hence, it's quite difficult for professionals to move forward with this, and there's been a lot of questions sent to the Home Office to clarify this question. However, so far we haven't heard a clarification from them. Yeah.
Okay, Steve, have you got anything to add on that?
No, all I can say is I'm disappointed but not surprised.
Okay, thanks very much. Okay, do we anticipate any changes in relation to GDPR post-Brexit? I'm guessing not. I think it's already embedded into legislation in the UK, isn't it? So I think it's highly unlikely that's going to change it anytime soon. As in, actually, most employment laws are already UK laws now. So the chance of them changing post-Brexit is quite unlikely, I'd have thought. Does anybody have anything to add on GDPR?
I think that would be my view and hope as well.
Okay, thanks very much. Okay, can a UK resident and national with dual EU27 nationality, who then moves to EU27 on landing there, be treated as EU27 national? This is dual nationality, so I assume so.
Yeah, if you already hold an EU nationality, even though you do have a British nationality as well, if you basically use your other passport, yes, of course you will be treated as an EU national.
Okay, thanks very much. Okay, will employers who currently employ EU nationals need to ask their employees to prove they have settled status, or is it enough to rely on the fact the employer in the past has seen their EU passport before employing them?
That's where the ambiguity lays at the moment. So current guidance says that you cannot ask your EU nationals to provide their right to work in the UK apart from showing their EU passport or EU ID. Therefore, no, you cannot ask. I mean, you cannot force it onto them. If you obviously ask a question, just simply have you applied, because we are your employers and we care because we want you to stay in this country. There is obviously no harm. However, you cannot demand.
Hang on, let me just clarify that a second. So if somebody's been working, so someone's an EU national and they've been working for you since 2018, for example, and that you want to check what their status is post the 31st of December, you can ask, but there's you
cannot demand. No. To be honest, the current Home Office guidance is that those who's already been employed by you for, you already employed them for a certain period of time, you don't actually have to do the repeated checks. Hence, we do have a suspicion that there's going to be further guidance released probably at some point next year, because it's a little bit strange that they would just say, okay, that's fine. Who's ever been here, they're fine. We don't have to check anything.
Okay, great. Okay, so people who now are completely worried, with regards to updates and stuff like that, what's the best way to try and find out what the latest changes are?
In terms of immigration, the easiest probably way is to just follow really government website, even though it can be very confusing sometimes. But they do tend to release updates fairly quickly and very often as well, especially obviously now when everything is coming to the deadline. That would be probably my suggestion. Alternatively, of course, you're more than welcome always to reach out to us.
Okay, perfect. Okay, great. I think I'm going to ask the guys to go back on a couple of specific questions directly to the people that asked it, particularly around the D visa, which we now know it's issued by Germany for stays over 90 days. But I'm going to ask you to go back directly after this because it's quite a specific question, if you don't mind. But aside of that, I think oh, hang on, we've got one more. Many thanks, awful lot on board, 100% still up in the air. All right, okay, it was just a comment, so thanks for that. Okay, well, look, thanks very much on behalf of everybody. Thanks for joining us, and I'd like to extend my thanks to Vaida, Steve, and Rahul for joining us this morning. And as always, we will be sending out a questionnaire to you to see whether or not this was valuable. Please do fill it out. It really does help us position how we're presenting this, and also it'll give us some idea for topics for the future as well, because I imagine this one's going to be bubbling around well beyond the 31st of December this year, I'd have thought. Okay, so yeah, so that's it. So thank you very much for attending, and thanks again to the panel.
Thank you.
Thank you very much.
Thank you.